floor to Ben.
Thank you, Patricia. Thank you, Marta Elena. Thank you, Patrick. I have to say, I feel like a bit like a marshmallow being pushed towards the flame. I'm very happy to be here, and I'm very happy to be invited by the staff union to address this quite difficult and knotty issue. There's just a couple of things that I just want to make clear from the outset, if I may. The first thing is the use of the word seize. We have no power to seize, and nor do we. I should say that we're very, very wary about personal property, and we're even more wary about personal privacy. We're actually institutionally adverse to asking to take possession of private property, because that's precisely what it is, and we don't routinely ask for private property. So to set everybody's mind at rest, I can say that we're not going to wrestle anyone to the ground to take possession of a mobile phone, nor are we going to turn up at anyone's front door in Westchester County, demand access, go into a bedroom and remove their MacBook Air to assist with one of our investigations. I have to be very, very clear about that. We don't seize anything. We work by consent, and we work within the established legal framework of the United Nations. Now, just very briefly to talk about some figures. At any one time, we have around 300, and at the moment we have 302 open investigations. Last year, we opened a total of 381 investigations. That's probably involves, at the moment, 302 open investigations may represent up to 350 individual staff members. Since the pandemic started and we went into lockdown on March the 13th of this year, we've taken, sorry, I used the wrong word. We have been provided.
I apologize, Ben. Can you turn on your camera by any chance?
Yeah, I've got paper spread all over the place, and I'm looking in different directions. I'll put it on when I've finished, if you don't mind. During the pandemic, since lockdown started on the 13th of March 2020, we have taken or been given or provided, to use the wording in the STAI, 3 personal telephones, 2 of which you obviously know about. And since the 1st of January last year, we've asked for precisely 6. You've got your mic on, Pat. We haven't taken anybody's computers. We've taken 1 hard drive, which we found connected to an office PC when we went round to get the PC. The main reason that we ask for mobile phones is their use in relation to sexual harassment. That's the principal driver for us requesting them. There's 3 things I want to talk about. Essentially, the SGB, the STAI, and privacy, and if I may address Alex's points about the nature of our investigations, I will do so. So, SGB 2015-4, we use it regularly, but we use it very restrictively. We interpret the wording in the SGB very narrowly, and we use it mainly to access email, which we do routinely and regularly because, as I'm sure you'll understand, email is a ready source of evidence. We will from time to time take hard drives, but again, generally in fairly restricted circumstances where we're looking perhaps at an incident where the computer itself has been used in misconduct, where documents have been created and perhaps deleted. So that's really 2015-4, very narrowly interpreted, and it's generally speaking about UN-owned OICT assets. STAI 2017-1, with its section 6E, which puts on us or reminds us all of our duty to cooperate with properly authorized investigations. What this means, this provision, it enables us essentially to ask the people who are being investigated for anything, and we can and regularly do ask for items that we believe contain evidence that are germane to our investigation. So we ask for their consent to provide, and thank you very much for putting up the relevant section. Now, OIOS will only ask for this information or this material if we believe that it's relevant to or germane to our investigation. We don't go on fishing trips looking for random pieces of information, and if the and failure to cooperate is not a matter for us to determine, or misconduct is not a matter for us to determine. We report on facts. So if we had asked for, say, a mobile phone, and we believed that it contained evidence and it wasn't given to us, we would flatly report in our investigation report that we asked for the phone and the staff member wouldn't give it to us. And we believe, on the basis of the following, that it contained evidence germane to our investigation. And then it's for the lawyers in the Administrative Legal Division to determine whether that amounts to unsatisfactory conduct and whether that amounts to misconduct, and if it should be sanctioned. And that's not an issue for OIOS. Alex majored on the issue of privacy. We take, as I've already said, we take the issue of privacy very seriously, and we've written into all of our procedures and our practices and our processes rules to prevent us going off on random fishing expeditions, looking for random pieces of information. When we take possession of any item of OICT equipment, we have to show before we examine it, it has to be shown that the equipment was obtained lawfully, that the material that we're seeking to find is proportionate to the investigation, the matter under investigation, that the request for it is justified, and that it's necessary for the investigation. And we also draft a plan on how we're going to deal with the issue of what we call collateral intrusion. That's where we find material or see material that really has nothing to do with us, and how we're going to deal with that issue. And this is all documented, and as part of the process is signed off by myself before the digital forensics investigators can examine a piece of OICT equipment. So the issue of confidentiality and the issue of privacy and due process rights are written into everything that we do, from the receipt of a complaint to the eventual closure of an investigation. So We conduct administrative investigations. We don't conduct criminal investigations or quasi-criminal investigations. We have no power to stop and search, no power to arrest and detain, no power of entry, search and seizure, no power of subpoena, and no power to mount physical or electronic surveillance. We have that that section that's on the PowerPoint in front of you. The worst thing that can happen from one of our investigations is that somebody's employment can be terminated. The reasons that I'm sure you're all aware why there are other checks and balances in the criminal system is because an individual's liberty is at stake. We're merely part of the Secretary General's accountability mechanism. And as I say, we conduct administrative investigations. We are neutral fact finders, and we report on facts that we discover as part of our investigation. I'll call it a halt there. I'm quite happy to take any questions that may be thrown up, and I'll hand back to you, Pat, and I'll put my camera on. How about that?
Thank you so much. See you. Can you turn off your mic now?
Sorry.
Thanks, man. Okay, so I would like to give the floor first to Francisco.
Hi. We were following you, Ben, and we had several discussions before. And
thanks, Patricia. Marta Elena and Patrick have really said it for me. Really, it's obviously we're independent of the administration. We're not the administration, but we do participate in the revision of the SGBs and the AIs that are relevant to us. And obviously this one is, and I have suggested that our internal processes and procedures in relation to necessity and proportionality and so on, which I have to say are based on the UK's Regulation of Investigatory Powers Act, which is in turn based on a series of decisions from the European Court of Human Rights. We've suggested that actually be incorporated into the new SGB as a privacy consideration, and I hope that just from the figures, I've allayed the fears of any staff that we're just going to suddenly turn up and start demanding their mobile phones or their MacBook Airs, as I can see from here. So thank you very much, and thank you for the opportunity, and thank you for listening. Thank you.
Thank you so much, Ben, and actually we thank you so much